So again, I'd like to welcome Levi Ainsworth, who's a partner at Ainsworth Gorkin LLP, a very well-known and established law firm that specializes in business. This is their area of expertise, helping businesses of all shapes and sizes. And he's digging into his experience. I said to him, when you make this workshop, what are the common issues that business owners ask you? Let's touch on those. So that's what it is. As he'll say himself, again, nothing that you hear here today constitutes legal advice. It's guidance, but it's not. If you want to, every lawyer will tell you, right? In order to get official legal advice that you could rely on, you have to you have to consult one-on-one. That's just the nature of the. So tonight is today we're covering generalities and principles, and so without further ado, Levi, welcome, and please take the floor.
Thank you very much, Yeshua. The reason for the disclaimer is mostly because lawyers just really want to get paid as opposed to giving free legal advice. But putting that aside, in all seriousness, this is not legal advice. This presentation is not for the purposes of giving you any legal advice and will not create a lawyer-client relationship as a result. For that, you're going to just have to pay me, unfortunately. But moving forward, as Yeshua was kind of indicating and saying, presentation today is not for the purposes of going too far into detail on any specific issue. These are issues that I just see a lot of clients having, or clarifications that are necessary, or issues that startups or early on businesses are either just unaware of, don't really know how to handle, and I think it's just good for them overall to have a strong understanding of. As a way of background, I'm an attorney licensed in New York. My partner, as Yeshua did say, is Shai Gorkin, and we have a firm together with a couple of associates. Our firm mostly handles a wide range of business-related transactions, litigation, detailing partnership agreements, financial transactions, buying, selling businesses, and wide range of litigation. As of right now, there's approximately 33 million small businesses in the United States, which makes up 99% of all businesses in the United States. The scary thing, though, is over 20% of new businesses are going to fail within the first year. Very few end up going the distance. I believe it to be just under 5% actually last above 20 years. What this really highlights to me, and I think for most small businesses, is the importance of planning. We all plan for the best to happen, but a part of that planning has to be realistic and the ability to pivot, which means fleshing out, whether that's with your partners, your customers, or understanding the temperature in your industry and understanding where to protect yourself, how to deal with it and get ahead of it. So I'll kind of just jump into just starting off businesses in general and the different structures that can be made. Commonly, there's pretty much 4 that are used. There's sole proprietorships, LLCs, limited partnerships, and corporations. There are other variations, but I'll kind of keep this the most succinct as possible. A sole proprietorship is essentially an individual that obtains an EIN. Super simple to start. From a paperwork perspective, there's not much to do. There's no partnership agreements. It's really for, I would say, gig type workers. So let's say you're a contractor and you're working on one of those websites that you can connect with potential customers. Sole proprietorships work really well for that. However, it does not really protect you from a liability perspective. So if as a result of that service or work, there's some level of liability or an issue arises, the liability would tack directly onto the individual owner of that sole proprietorship. A limited partnership is a little bit of a different variation where there's a general partner that will have quite wide-ranging authorities without the need of the limited partners. And usually this is used for private equity companies or like investment style companies. Sometimes it's used for real estate, but not often, where you'll have one partner that really kind of takes the reins, manages the company, and then brings on investors who tend to be limited. On a taxation level, there's the protections where you can have the deductions and things like that. And there is protection from a liability perspective as it is a limited partnership. The other two most commonly known are going to be a limited liability company and a corporation. For quite a long time, most people were using corporations. Still to this day, you'll see most IPO companies are corporations, although that's starting to slightly change a little bit. A corporation is a lot more of a formal structure where you have boards, you have to have officers in place, and it's anticipated where there's two separations. You have your investors, owners of the stock, and then you have the officers that are two entirely separate people or areas within the company, and they kind of function like that. One of the key things there is, or two key principles I would bring up with corporations, is it's a double taxation for C corps versus, let's say, S corps or LLCs, which basically means the corporation itself gets taxed, and then upon any distribution to the shareholders, they get taxed on that individual level. So C corporations are good if there is intended to be a very long term until profitability, or going IPO or something of that nature, where any income you kind of want to keep it as minimal as possible. However, corporations' downside is they are very rigid. There's statute in place as to how they have to be managed. You have to have a board, you have to have bylaws. There's not so much flexibility. So for example, let's say you guys want to have a 50-50 partnership. However, you have incentives for whoever brings in business to get 10%. You can't do that with corporation. It gets quite complicated because whatever the equity stake is how distributions have to work, which then brings us to LLCs, which is more of a newer structure. When I say newer, I'm referring to the last 30, 40 years. LLCs also are dictated by statute. However, you can essentially write whatever you want and structure however way you want. So you can have a 90-10 partnership, but decisions get made 50-50. You could have a board, you don't need a board. And it was a lot more anticipated for it to be, you're going to have your investors and your officers could be the same people. So there's a lot less formalities that you have to maintain. You don't necessarily have to have meetings. You can waive those requirements. So I've personally seen LLCs almost used exclusively. Very rarely do I see corporations these days, unless there's a specific reason. From a tax perspective, it's a flow through. So there's no double taxation. Just at the end of the year, with the K1s, it gets filed. It comes into like ordinary income to the owners. Part of starting the business is always going to be the formation documents. And unfortunately, what I've seen quite often is when it is only one or two people, this gets kind of pushed to the background. Businesses are busy, trying to really kind of get to a revenue profitable place or any sort of revenue quickly. And that becomes incredibly busy, and this gets kind of left to the background. As a result of that, I've seen clients that they've done a bunch of work on putting an operating agreement together, for example, never signed it, and a year later, which I'm actually currently trying to deal with an issue that they're dealing with now. And the problem is there's no agreement in place. Even though it was negotiated, everything was done pretty well. The problem that inherently is there's no binding agreement because it was never actually signed. So it's important to kind of go through the steps in order to get those things done. And there are several things I think are incredibly important to flesh out early on, especially in a partnership agreement. You really need to have the clearer the obligations and the roles, responsibilities are, I think the better. And what it avoids is ambiguity. Ambiguity in contracts is kind of where core issues end up arising, or disputes. Because if the contract doesn't deal with it, then how do you deal with it? And that's where the disputes really arise. So what I always advise my clients to kind of go through, what are the expectations of each partner? And then importantly, which very rarely do I ever get this answer, is what happens if they don't keep their end of the bargain? I think most people don't really consider that, but I think it is imperative to really consider that. So for example, if you have an investor and a sweat equity partner are 50-50, right? You're the sweat equity, you're doing everything you can. The investor all of a sudden now is supposed to invest, let's call it $100,000, for $50,000 the way in. They can't give you the next 50. What are you going to do? You don't really have the equity there, so it's a breach, but then what's the result? You're not going to sue them. It's very expensive. It's difficult, puts you in a very odd spot. But if you deal with that day one and say, hey, in the event that you don't fund the full amount, your equity gets reduced. You can kind of put these things in an agreement. And I do feel it's important, especially for anyone with sweat equity or the founders and not the investor, to have that idea on it. There's been numerous times where that happened. Because if they're a month late on funding, it creates issues within the company. And then how do you deal with that? It's a little bit of an awkward conversation as well, because you're going to your investor, can't really frustrate the relationship too much because you still need the investor's money. But now the company now is at a disadvantage of where it should have been, and likely is going to be a long standing issue, where then it starts creating frustration in the relationship that also starts kind of eventually may break down as a result. So it's really important to understand what the roles of each party is, what the result is in the event that they don't keep up their end of the bargains, understanding what they can or can't do. So if there's exclusivity, like this is the only thing I'm working on, I'm not working on other companies, or can have other employment, first rights of refusals, whether you're buying or selling your equity, in the event of a dispute, how that works, whether that goes to arbitration, litigation, which I'll kind of touch upon a little bit later on as well. And then kind of just going through the process of like the day-to-day, how things work, which decisions need both of you, don't need either of you, and who manages what. I think that's usually brushed through quite often. That ends up becoming a bigger issue as time goes on. I think it's really important to kind of, with the business plan, you kind of really plan as to who is responsible for what, and what that typically will end up looking like, and if they don't hold their end of the bargain, what that looks like. If not for just having a clear arrangement, I think it's also on a personal relationship basis. It's a lot easier to go into partnership with someone where both parties are very clear on what the responsibilities are and what happens when they don't. It doesn't create a fight because you've already dealt with it. So though it's difficult in the beginning, I've seen it when this process is done well, it really helps avoid issues down the line, and kind of allows the business to continue going even through some rough patches that may occur. So obviously, once you set up the business, you have your partnership agreements ready to go.
1 second. So you're going to the new topic.
Yeah.
Let's just, if anyone has any questions right now on this first topic of partnership agreements, setting up your business. If there's any questions, you want to raise your hand, you could raise your hand and you could ask your question verbally.
Yeah, this is Ellie here. Quick question.
Okay. Yeah.
If someone does have a C corp, I know you mentioned that you have to have a board of directors and you have to have a couple things. Is there any penalty for not doing that, or that if there was an audit, that would be an issue?
You may not have the full protections of corporation, arguably. Okay. So it's important to kind of keep it together, and especially for corporations, there's a lot more formalities. So every time you have meetings, you have to have minutes. You have to have a lot more paperwork that's put together, and too many startups, this is the last thing they concern. Now, you could easily fix that when that need arises, but if issue arises earlier, they may be able to pierce the corporate veil. There might be it might open the door for some other liability that is obviously not optimal.
Got it. Thank you.
All right, there was also a question here put on we'll do one question now, and then guys, like I said, a lot of questions are going to come in. Well, one more question, and then we'll save the other one for later. Shaiki asks, what are the pros and cons of sole proprietor versus LLC? I know you touched on.
Yeah, so the upside for a sole proprietorship, it's super simple to start off with, really not complicated, and it's usually used for individuals that are starting to do like a side hustle where they can kind of have a EIN separate, but liability, there's zero protection. Whereas an LLC, you have liability protections. Again, there are some exceptions to that, like they can pierce the corporate veil. So when you have your company, it's imperative to maintain it separate and distinct. And this is a concept for non-lawyers that gets lost quite often. You are not your LLC. You are not your corporation. So you need to ensure that there's separations. If you start flinging money from different accounts and everything's a mess and can join together, in the event of a lawsuit, there's something called piercing the corporate veil, which means you're not maintaining this as a separate entity in and of itself, distinct from you. And therefore, I can pierce that and then connect to other entities or to the individual behind it. That is an incredibly high bar, but a lot of startups, again, there's things moving around so often, it's imperative to kind of keep a distinct separation. So all the business expenses should go through there, but you shouldn't necessarily be starting to pay personal stuff through there. Having too many different calculations of lending, giving back money, if things are a little bit too much of a mess, it creates issues. But I would say the biggest upside of LLCs is there's tons of flexibility in how you can structure it, how things work within it, and you have the protections of liability. So for example, if something happens, the liability maintains just in the LLC. You personally are separate and distinct away from it. They can't sue you as an individual. They would sue the company.
All right, so there was two more questions that came in. I'll bundle them together, and this will be the last one for now. Okay, so basically, Tova asks, how does one know when to transfer from a sole proprietor to LLC or S corp? And someone else said, can you start a sole prop and change to LLC? So they I guess that sort of goes together, hand in hand.
So I would kind of look at the sole proprietorship as an extension of you. I won't really look at it as transferring it over. The only thing that you would have to consider kind of shifting over, essentially you would have to create an LLC or corporation. The only thing that you would need to kind of move over would potentially be any IP, which is intellectual property. So any branding, any inventions, any copywriting, any things like that, you may need a paper to transfer it over. So it's an asset of the new entity, but you essentially, it would be two distinct things entirely.
Okay, let's move on. If you have more questions, hold them. Again, at the end of everything, we'll do a full Q&A. All right, go for it.
All right, so once the company kind of gets up and running and starts, you're going to start dealing with just operational issues. I'm going to give a disclaimer. I don't do a ton of employment or labor law stuff. I do deal with it, obviously, from time to time as clients have it, but I usually bring in, depending on the complexity of the issue, I will refer this over to other counsel. And it's employment law and labor law is a growing complex area. So always important to kind of consult, even firing someone. You got to be careful about how you do things. However, recently there's been a very difficult ability to fill a lot of the jobs lately in the US since COVID. And what I have been seeing is a lot more clients that are trying to incentivize employees to come on board with potential bonus structures or equity or things like that. So in general, it's really important as a first and foremost, even if it's a basic employee and nothing overly concerning, there's no vesting interests or equity or anything too crazy. It's always important to have a non-disclosure or confidentiality agreement with employees for a variety of factors, which I'll kind of go into in a little bit more detail when I discuss the IPs. But essentially what that does is it kind of dictates that, hey, we have certain information that's trade secrets that you can't just use outside the business. Additionally, with employees, if they're working on something for the company, on company property, you would really want to be able to say, well, that's company assets as well. So if let's say you develop a new brand or logo or things like that, can't really say that's yours distinct versus the company. So there's small things that really help protect the company moving forward. You obviously want to have non-solicitations, which basically means employees can't really go after termination of their employment, go after your clients, customers, or other employees. So you really want to kind of protect your company as much as possible. I do know that most people don't like going through this process because you want to just run, but having even a template form basic employment agreement that covers, I mean, just the confidentiality, maybe not some non-solicit things like that, I think are quite imperative. I would also say take a breather on providing or guaranteeing any equity incentives. And the reason is, I'll give an example. I had a client of mine a while back, brought in a consultant. They were doing a variety of different investments, and the consultant was supposed to get about 10% equity. We kind of discussed it a lot. I discussed a lot with my client. I said, you mean, where is this person coming from? What is the reason that they should be getting it? They're quite qualified. So that's kind of where the conversation came from. But I said, you've never worked with them, and this is essentially a marriage. So you're kind of tying your hip to this employee, but you haven't worked with them. They may be quite qualified, but that might be great as a consultant, not as essentially a part of your business. I ended up kind of convincing him to pay the person a little bit more, not give him any equity, and then have the conversation in a year. 6 months in, he kept calling me really gratefully saying, I'm really happy there was no equity. This is not working out at all. And I'm happy to pay it a little bit more just as a straight salary and avoid having any equity. So, I mean, there are ways you can pull back equity, but again, those agreements get quite complicated. Then you start going to for cause, not for cause, what they mean. So, I mean, it's important to really have these considered thought process, especially now with like equity being offered by a lot of smaller startups. And another issue I see quite often, especially with startups, is designating a lot of people as independent contractors versus W-2 employees. The difference is quite glaring from a liability perspective. There are a variety of different liabilities that can result. You can be having to pay back pay overtime. You may have to pay employee benefits. You may have to pay disability payments, tax issues and insurances like workers' comp. There may be liquidated damages issues, and there may be civil penalties from like DOB, the Department of Labor and things like that. So it's really important to understand, are they an employee or not? A couple of the factors, I'm not going to go into detail because there's quite a long list of things that really designate it out. Independent contractors are people that don't just work for you. You are one of their customers. So if you're the only customer of theirs, it's more likely than not that they're going to end up being designated as an employee. If you control the work they do or the time they come into it, again, that's going to be a lot more closely designated as an employee versus if you just say like, hey, here's a deadline, this is a project, and you don't really kind of hold their hands too much, more likely that's an independent contractor. So important to kind of designate them correctly. And also, there are differences on what you're going to be able to handle, restrict an independent contractor versus an employee. An employee can have, let's say, you can only exclusively work for me versus independent contractors. You just can't have that in there because it's inherently not what an independent contractor really does. But this is an issue I've seen quite a lot, and thankfully I haven't had many clients have this issue actually come to the forefront of penalties, very rarely, but it is there and something to constantly be on top of. Of note, the FTC recently ruled that non-competes are no longer legal. This is going through a whole battle from a constitutional perspective. There are most people think that's going to get struck down eventually, but as of right now, the FTC outlawed it. So there's constant change in this industry. Also note that, especially in New York City, there are certain disclosures you need to have hung up in your offices. If you use like a payroll service or things like that, almost certainly they'll include it. Those are some basics, but be important to always try to be as compliant as possible because you never know who you're hiring. Intellectual property. There's four main areas: trademarks, copyrights, patents, and trade secrets. So the trademarks, copyrights, and patents, you can all get those registered. With the trademarks, that's where you'll see the symbol. Like it's usually used for brands, logos, things like that. So whenever you see it, you see the small r, that just means it is a registered trademark of the company. You can't use it. Copyrights is really about works of art, music, dancing, literature, and software, a little bit different. And then patents is more about like inventions, discoveries. The most usually used is like utility patents. Lastly, and this is kind of, I'm going to assume the most relevant for this topic, is trade secrets, right? It's nothing that's going to really be registered, but it's every company has it. So it's going to be your financial plans, how you process your company, your customer information, potentially your vendors, things that are not necessarily public information, but you somehow obtained it and worked for it or paid for it or got it. That's not on the public forum necessarily. I do believe that most companies don't really consider that all that much. We've had actually a couple of years ago, we had a lawsuit specifically on that issue, on the trade secrets, where we had two employees, or actually were designated as independent contractors, left the company and had some of the customer information. The company sued them for saying that they took trade secrets. However, the issue was, number one, there was no confidentiality agreement in place. There was no non-solicit of any sort of the customers either. But additionally, and this became the key factor in the agreement, there was no way for the company to actually show that those trade secrets were truly trade secrets and that they weren't just public knowledge. So we were able to kind of, through the lawsuit, we were able to settle out quite quickly, but had to use some creative ways of getting there. But the importance of that one is on two folds. For the employees, they were able to kind of get away with it because it was public record. They had no restrictions on them. But for the company, had they had an NDA simply in place, it would have really shifted the entirety of that litigation, and almost certainly we would have still been dealing with it to this day. So that's kind of where the NDAs really do come into play. And the same thing when you start talking to other businesses. whether you're selling an asset or whether you're going to start showing someone's proprietary information about your company that you're concerned that if they use it improperly, it's going to negatively affect you. Those are the times where the NDAs come into play. So I wanted to kind of just touch upon in general.
One second,
contracts.
Sure. So before we jump over to a whole new topic, there was one question posted, and if people have questions, someone says, "What is the right way to get paid if you own an LLC?" That's the question that was asked.
You mean like on a salary basis, or it would be a distribution, really?
Right.
So there's a couple different ways. Technically speaking, you can't be a part
One second,
of
maybe
payroll.
to clarify, the question was asked by Shaiki. If you want to unmute yourself and explain your question instead of us guessing. Okay.
Yeah, thank you.
Okay, I'll go ahead. Yes.
Yeah, it's like, what's the right way? You do yourself a payroll, you do just pulling money and put it at the end of the year on 1099, it's K1. Like, what's the right way to get paid if you own the LLC, you're the owner?
So there's a couple different ways you could do it, especially if you have, are you the sole owner in this scenario, or are there other partners?
In the scenario, yeah, the sole owner.
So there's, I would almost certainly just do a distribution. It's probably the easiest. I'd speak to your accountant about doing it the most effective way. You can also do, when you have partners, you can't really do payroll. Technically speaking, can't be on payroll for your own companies. You would have to do like guaranteed payments. There are some technicalities how to deal with that. But generally, if you're the sole owner of the LLC, I would say distributions would be the smartest way of doing it and easiest.
Distribution meaning K1?
Through the K1s, yeah. But again, that's all. Speak to the accountant. I don't want to give any tax advice specifically, just because that's a whole different ball game. But yeah, generally speaking, I would suggest going through the K1, contingent on you speaking to your accountant.
Yeah. Okay. Thank you.
No problem.
Okay. All right. So let's move on to the next. If there's more questions, remember, we're going to do a general Q&A at the end. So go for it. Contracts and agreements.
So I wanted to just touch upon contracts in general, process of how that goes. I feel a lot of the times contracts with clients go a variety of different ways. There's people that disregard, don't understand or care for the value, and will sign whatever goes in front of them as long as the deal goes forward. And other clients that will negotiate ad nauseum on things that are completely and utterly irrelevant. So I kind of wanted to just touch upon the process, the documents that are needed, and things like that. I'd say at the start of it, negotiating, it's really important. Number one is, whenever you're doing anything, have your own counsel. We've had a couple of cases that ended up turning into litigation where two partners started a business. It went terribly wrong. There was only one attorney who was really acting on behalf of one partner's best interest. Even though our client thought they were being represented by that counsel, truly they weren't, their best interests were not being put forth. So really important you have an attorney that's representing you individually or your company's specific interests. Otherwise, attorneys really, they'll give you general advice. They don't really care if they're not representing you, because there's no representation. But if they're representing you, there's going to be a lot more thought. There's going to be a lot more consideration as to what your position is. I'm currently dealing with another client of mine who's investing into a business. It's getting quite complicated, and we need bankruptcy counsel. They spoke to someone else that was already involved. I'm like, you need to have your own counsel. Ended up being, advice was quite different than what that original counsel did, because it was a little bit more by the way type of advice, and it just didn't fit well. So we ended up getting bankruptcy counsel who ended up giving really good on-point advice that really helped save what could have been a lot more of an issue. So it's really important to understand who represents you and make sure that you have counsel yourself. When negotiations start, and this happens quite often, really understand what you're trying to get out of this relationship or agreement. It's really important not to have a back and forth where you pivot and change your position constantly. I have found that really frustrates negotiations quite a lot, and also having too many people involved in that negotiation, or as I like to say, too many cooks in the kitchen, is terrible. There's tons of miscommunications. No one really knows who's supposed to speak to who. And all of a sudden, before you know it, there's a bunch of information that's not quite accurate, but everyone's kind of using different pieces of it. And it creates a lot of confusion. Me personally, when that happens, I jump in and kind of say like, hey, let's all jump in a call, have a conversation, and then appoint one or two people from either side to communicate, and that's it. And it really helps kind of just take the temperature out and get to the end goal. Obviously, as negotiations go, and I have seen this from some clients where they view every negotiation as a win and loss. And they're just like, every point that they want, they hold on to, and they ensure that they get every benefit. I don't think that's a smart way of negotiating, because once negotiations are over, the relationship's truly starting, and you don't want to start really on a bad foot. So really consider what you want, what you don't. You can always have in the back of your mind, things that you don't care about. Great. You don't have to give it up day one. Don't mention it, give it up later. And that's your good faith, because you got to always show it on both ends, because again, you're going to work with this person or company thereafter. A lot of you are likely or may not have dealt with a letter of intent. It's not used on all type of agreements, but generally speaking, what it is almost like a term sheet. It's used in a variety of different transactions. I mostly see it in the M&A deals I do, or financial transactions. It's really helpful early on complicated transactions to just get the parties on the same page. So where there's a lot of moving pieces. So for example, M&As referred to as mergers and acquisitions, like buying, selling businesses or assets. There's a lot of moving pieces. So it just ensures that the business terms are pretty much front and center. How much you're paying, timing, what the assets are, how long you have for due diligence, like a variety of things we're on the same page. Now everyone feels comfortable moving forward. Happens to be on M&A deals. Usually at that point, there would be an exclusivity clause that they can't really talk to anyone else about doing a sale. They have to stick with you, but not so relevant, or there may be a deposit, a variety of other factors that may be in there. I do find that they are useful, but I have found also that some clients overly rely on like LOIs or MOUs, and they'll put so much effort, work, negotiations into that, whereas that could have just gone straight into the agreement. There's no need to for that step. So it really depends on the type of transaction you're kind of working on to, or working with, that whether or not you need that. The one thing is LOIs and MOUs are inherently not binding. It's basically a promise to go into another agreement, which is, in legal jargon, there's no proper consideration. You can't promise to go into another agreement. So it does get complicated where people believe they have a strong agreement. I've seen this before, where they'll get a signed LOI, they'll start doing the business, something breaks down, and it's like, what? Well, it's not really an agreement, and didn't flesh out all the issues. And before you know it, you're already doing business, and there's no concrete agreement. So avoid at all costs doing too much business, or at all. My advice would be at all, until you have a definitive agreement in place that deals with all the issues, and you have a real full fleshed out agreement, as opposed to just an LOI, because it's not close to as comforting as people think it to be. All right, so key terms on different agreements that you'll see. A lot of different clauses in agreements are going to have effects, and this is only some. It really depends on, I mean, if it's a distribution agreement, service agreement, contracting agreement, there's tons of different ones that we can kind of go through. But this is just to highlight some of the clauses that I see that are useful. I do feel that some clients also tend to shy away from complex contracts, but the reality is quite often there's a chunk of agreements that aren't necessarily overly needed. However, on the flip side, fleshing out everything, what the obligations are. So for example, let's talk about a distribution agreement. I mean, when does the liability of the goods become yours? When do you own them? Who has to have insurance while it's in transit? If it breaks in transit, who pays for it? Whose insurance does that get claimed under? What happens if you get the goods and there's an issue with it? Or what happens if the numbers aren't right? How does that all go through? So it's good in the agreement to say, well, you mean you have 30 days to make any dispute of anything else. If you want to return anything, how's that work? Do they give you cash refunds? Do you just return it? They replace the goods? So, and I've dealt with enough clients that like a lot of times like that, it doesn't matter what goes in a PO. Inevitably, there's going to be an issue. And inevitably, those terms now would have really helped had they been in place, because it would have given you a very clear path to what is supposed to happen, versus now it's like, goods aren't good, and they just start giving you a credit. You're kind of stuck when you don't want to work with them anymore because their goods are constantly not good. So it's important to really consider those things with a distribution agreement, whether you have exclusivity or not. Personal guarantees on agreements. So like I was saying before, with Pearson and Corporate Veil, sometimes on agreements they'll want to have a personal guarantee. So let's say if the company that's contracting doesn't really have much assets or hasn't been in business quite a long time, there's a level of risk working with them. You want some individual tied to the agreement. So those tend to come in quite useful at times. You may want to consider competition consideration. So for example, if they're working with you, they can't work with other vendors, or territorial competition. So if you're, let's say, a supplier of goods, you may only divvy up certain distributors for certain areas. So Florida, California, and you may want to strategically think those through. How payment terms work. You mean whether it's paid upon receiving those goods, net 30, net 60. What happens if they're late? And if they're late, you want to kind of add in some sort of clause that any payments get a late payment, a one-time late payment of X amount of dollars, or it's ongoing percentage that they have to pay for everything outstanding. I feel those really help when it's late for a while and they finally are able to pay. You have some room to negotiate, so they're not trying to get a better deal on the principal, or they'll try to get rid of some of the late fees. Also, if there are any breaches or issues, are there a cure period? Meaning, can you fix that issue and then move on from there, or are there not? Also, part of this, and again, I'll discuss this a little bit later in more detail about when it goes into litigation or an issue arises, but choice of law, venue are also important considerations as to if there's a dispute, where does it go, what state, and what venue? Are you going to court, arbitration, mediation, things like that. Last one I'll touch upon that comes up quite often is also indemnification. So if there's an issue or liability that arises, you want to have clauses in there that really discuss protections for you and for your company. So if a liability arises, whose is it? So you want to kind of dictate that if they breach the agreement and liability arises, they're going to be liable, and they have to cover if you get sucked into the litigation or something like that. They'll be on the hook to pay you for those costs and things like that. So there's, again, this is just a very small pool of clauses, but it really depends on the type of transaction you're kind of running into. But a really key overarching issue is you got to remember who you're going to contract with. It's really good to have a very distinct, complex transaction and any contract that really deals with every possibility. Reality is contract's only as good as the person you're going to contract with. So there's a level of trust here. The bigger the company, the more trust they're going to kind of come through with it. And if there's an issue, they're incentivized to deal with it, because a lawsuit or a judgment is going to be too much of a hindrance to their day-to-day business. But if you're going to business with someone that doesn't have any assets or anything else, and for example, you're lending them money, how are you getting that money back? What happens if they can't pay you back? Where is your remedy? So really considering who you're working with is important. And this goes not only for financial transactions, but across the board. When you're sending goods to someone on net 30, how strong are they financially? You don't want to get stuck where you sent goods and now you have to chase them for the payments or invoices and things like that. So it's always constantly know who you're dealing with and do check-ins, make sure that they're financially a viable vendor, client, or partner to work with.
Okay, so before we jump to the next one, does anyone have any questions about contracts? Any questions you want to ask as it pertains to contracts? Yes, you could ask it by typing it in the chat. You could raise your hand and unmute yourself.
Okay, can I ask a question?
Yes, go ahead.
Okay, I'll put my video on. As a sole proprietor I have a bookkeeping business going into an agreement with a client. What's the advantage and disadvantage of signing a contract?
What are the terms of your agreement without a contract?
I invoice you on a monthly basis and you pay.
Yeah. What happens if they don't pay you?
Then I'll stop doing the work.
Okay. How do you get paid? How do you get paid for the work you did do?
I've never run into the situation. I guess I would just keep asking, and then if they didn't, I don't know what I would do.
Right. So the question that arises, if you want to, let's say, take legal action, there's no definitive place as to where you're supposed to do it, which law you're supposed to be applying. Number two is, I would tell you, have a bare minimum. If you're not going to have a contract in place, on the bottom of your PO, you should, or invoice, you should write any late payments are subject to, let's say, a penalty, because otherwise, if there's no incentive for your clients to be paying you, they'll just push you off because the number doesn't shift. The moment the numbers just increases month to month, they have more reason, and it's a good negotiating tactic.
Right.
I would also say is for some bookkeeping companies, they like to say, if you want to terminate, no problem, but you have to give us 60 days notice. So you can buy yourself a little bit more time. It depends also if it allows you to shift on pricing. It allows, any other terms that you would want in there. How many hours? You have to guarantee you a minimum amount of hours. And if not, you still charge them a fee because you're making yourself available. There's a lot of factors to consider about how to structure. I hear these kind of questions all the time. Like, what's the point of the contract? It really depends on the relationships and what you're trying to convey. So for example, if you're doing bookkeeping, you're saying, hey, you have an unspoken rule. I'm making sure I'm available 10 hours a week. What happens if 1 week they only be 5? Is that really fair to you on your business? Not really. So you want to say is your fee is going to be minimum 10 hours. You use more, it's an hourly, but it's minimum 10. So it's really just protecting yourself and ensuring both parties are on the same page. I'll give you a great example. I actually just got off the phone probably 5 minutes before this presentation. He's actually a really good friend of mine. I've done some business with him. He tends to introduce a lot of people, and I always tell him stop doing it without understanding what your deal is. He introduced 2 people together that they're going to end up doing a lot of business. When he said, hey, how much am I getting paid? They were on completely different pages. He's now running the risk. He can't be aggressive because he may not get paid at all, but he has no leverage. And he never dealt with what the considerations were. So I think putting aside the legal, one of the best things about contracts, it ensures both parties understand what is expected from each other. I think that in and of itself is a huge benefit. Forget all the legal help that it does and everything else, just making sure everyone's on the same page. I feel like it gets lost because everyone's looking to do business. So you let the ambiguity be there until it arises as an issue.
All right. Okay. Yeah. Thank you so much.
Okay, we're gonna go on to the next section. I see Menachem, you posted a question. We're gonna save that towards the end because it's not directly related to this Osusun one. So, but I see your question and we'll get to it. Okay. All right. Go ahead, Levi.
This one I'll try to run through a little bit more so we have more time for questions as well. The next kind of area I wanted to kind of touch upon is I kept this more to seed level investing, which tends to be 3 million and below. Usually that's from family, friends, or what's referred to as angel investors who are relatively wealthy people, but don't do it as a full-time living or not going to make it overly complex. Most startups use 4 ways of getting investors on board early on. I will make note, some of these do trigger security issues. So it's important to have good security counsel. There's ways around having to, let's say, register with the SEC and things like that, like doing a PPM, which is private placement memorandum. Not for the purposes of this call, because that in and of itself will take hours to get through. But wanted to just touch upon the 4 basic usual ways investors come on board. One is referred to as a convertible note. It's quite similar to like self-explanatory to an extent. It's a note which is referred to as it's a loan that converts at a certain point. What normally happens is they'll be promised a discount. So if they give $100,000 at the next round of investors, they're going to also be given a discount. So let's say you give $100,000, you'll get a 20% discount of the next investor when the company is worth $200,000. So instead of having to pay, $100,000 for 50%, you can get away with paying $80,000 or however way that math works. But the key things in a convertible note are there is a maturity date. So if you don't have that next round, that loan becomes due and owing, and you have to figure out how to pay that. What ends up mostly happening is the investor has a lot more leverage because the company almost certainly will not have the funds on hand because they've already used it through the process, and they'll be able to extend, but on better terms. Instead of 20% discount, they'll say, I want 30% discount and a little bit more interest or things like that. And there's also an accruing interest with convertible notes. So this kind of puts some founders in tough spots because there's a lot of unknowns. So there's the upside is you don't actually have to evaluate what the value of the company is today. You're kind of kicking that can down the road by saying, whenever the next investor comes in, that's when we'll define what the value of the company is, and that's where your discount will come in as an investor, and you can convert into equity at that point. The downside, as I was saying before, is if you don't do the next round of equity, it does create a big advantage to the investor to push for better terms once again. So there's upside and downside. Because of that issue, where there's specifically a maturity date, a new form was really brought in, which is called SACE, which is a simple agreement for future equity. Those don't have any maturity agreement. It's very similar to a convertible note, minus the maturity date. So there's no end date. So it only really triggers once there's another investor coming in another round, and there's no accruing interest. This kind of made it a lot easier for founders to not have that pressure. I need to get to the next round or things like that. The downside with both safes and convertible notes, you don't really know how much equity you're giving up because it's all contingent on your next round. So it gives you the advantage of not having to deal with that day one, but it gives a disadvantage when you get to the next round. It may end up being a lot more equity than you anticipated. The next two are when you're actually getting the equity within the company. Stock is referred to as, for corporations, and LLCs it's usually referred to as membership interests, but there's two different types of equity interests. You can have preferred or common. Preferred basically means that there's more than just one group of equity holders. You'll have your common, which means everyone's the same, and then you'll have preferred. So usually preferred are going to be for more savvy investors that understand and specifically have the negotiation tactics or leverage to ask for specific terms that are favorable for them. So they may want to say, you can't bring on another investor without my say. You can't spend a certain amount of money. You can't move into a new industry without me. They may put certain restrictions and create them to be preferred. They may say that I want a accruing interest on my capital that's invested. They may say I get first dollars out until I'm fully repaid. There's a tons of different ways they can be preferred, but it kind of creates two distinct shareholders, one being preferred and one being common. So preferred tends to also be a lot of negotiations tend to happen, and it can be quite a complicated transaction to go through. Again, if you're doing this right off the bat, there's not much from a securities interest concern if you're doing this right when the company's being made. But if you're doing this later on, you'll have to kind of consider a lot more of the security implications. The next one is common stock, where it's basically everyone's on the same footing. There's no difference between any shareholder and or equity holder. Everyone's on the same wavelength. There's no real differences, unless again it's in the agreement, but generally everyone's on the same footing for voting purposes and for anything else. So it usually aligns quite well the founders with the investors, not really giving anyone too much leverage. But again, that really depends on how the agreement is drafted and how certain decisions are made, what the equity stakes are. There's a lot of specifics here, but generally that's kind of the viewpoint. And I do find a lot more often than not, there's going to be common, because again, preferred means whoever buys out the preferred equity stays preferred as well. So, and it can get substantially more complicated as time goes on and more investors come onto the table. This one I just wanted to touch upon because I have seen a lot of startups, I mean, they'll look for debt, but they're not necessarily as aware of what the cause of that is or what to be expecting from the debt. So there's usually two different variations of, sorry about that. There's two different variations of debt normally. There's term loans and then there's going to be revolving lines of credit. A term loan, in short, is there's a very finite period of time. You're given all the money, principal of the interest, and you pay monthly interest until the maturity date where you pay everything up at once. They'll almost certainly always, any business loan are going to have that you can only use it for business purposes. They may also specify, depending on circumstance, what you can use that money for also. But they tend to have higher levels of interest, whereas lines of credit are not going to be as high, but you will have to pay a monthly commitment fee because they have to ensure and designate a certain amount of funds to cover your line of credit. Problem with lines of credit as well is every time you draw out money, you're going to have to make new representations, and it depends on whoever's giving you the line of credit, whether it's a bank, whether it's private investors, things like that, how complex it will be and what you have to confirm. Normally there's no prepayment penalties and it's just revolving. So they'll have a limit of $100,000 you could use. Whatever money is out, you pay interest on, plus probably a commitment fee. Otherwise, that's fine. And it's really important on both of these, really important. Go through what the fees are, what your interest rates are, if there's originations, if there's that, because all of a sudden, you may think you're getting 100, but you end up with 97,000. You're like, where did $3,000 go? So it's really important to understand what you're getting into and what you're not. Part of that's also going to be whether or not the lender is secured or unsecured. Security interests usually come in the form of what's referred to as a UCC, which is similar to a mortgage, but not for real property. So it would be on all assets of the company. So IP, ARs, computers, whatever you have that's not real property, they can have a security interest over, which means in the event of default, they can essentially take that. So they can go straight to your customers and take your AR. They can go straight to take assets, things like that. So that's additional protections for secured creditors. They can also sometimes ask for a pledge agreement, which basically means if you default, they get a certain amount of equity as security. They'll also almost certainly always ask for personal guarantees on such loans. I've dealt with too many clients that had no idea what they were signing and signed off personal guarantees, what they thought were not. So it's also really important to understand, are there personal guarantees of what you're signing up for, what you're really giving up, and what the ramifications are in the event of defaults. The unsecured are more typically like your credit cards. There's not going to be personal guarantees. They're not going to be able to really go after anything. Their only real way of coming back after you is essentially suing for a breach of contract. So unsecured are always definitely the way to go. Hence why you see a lot of people go with credit cards off the bat, but they tend to be incredibly expensive generally because there's higher risk. After that,
A second, Levi, how
Yeah.
much, we've gone quite long already over here. It's almost a full hour. How much more do you have to cover?
I can skip a little bit of this. The only thing I want to kind of cover probably more specifically would be kind of litigation and how that works.
So I would
Jump
say,
into that.
for the interest of time, because officially it's an hour, jump to that and let's do Q&A.
Sure. So most people think litigation is a far cry from ever happening to them, but it happens quite more often than you would think. About half of businesses get into litigation on an annual basis. Almost all businesses experience a lawsuit or some sort of litigation at some point. As you can see here, that would 12 million contract lawsuits are annual, which would put it at literally third of contracts with companies are going into some sort of litigation or dispute. So it's really imperative to plan forward with that. I'll just jump over here. In order to avoid and or strengthen yourself for any disputes, you have to plan for it. So it goes back to contract negotiations and the terms that you're using. So you have to anticipate if they don't do X, what happens thereafter, how you best protecting yourself. So again, it comes to clear outline of responsibility of the parties, try to avoid any level of ambiguity, because again, more ambiguous, less clarity, judge is not going to know what to do. So it creates a lot more issues. Be very clear about, and we have another client now that got sued for their services because their services were very broad in general, and they claimed they didn't get any services, but our client said they did. And now we have to go through a whole process of explaining to a judge through motion practice that this is exactly what we did step by step, as opposed to if they would have really in the agreement clarified what specifically are their services, we won't be close to a lawsuit right now because it would have just been dealt with. So the clearer you are, the easier you are on these contracts, the better it is. It avoids a lot of litigation down the line. Most litigations result from just poor drafting, poor advice, and terrible agreements in place. The forms, there's three main forms in order to deal with any dispute. There's litigation, arbitration, and mediation. Litigation is usually before it goes, you go to a court, it could be federal, it could be state, there's a judge. It's predictable because there's case law, there's statutes that they have to adhere to. Downsides are it's public knowledge or public record, I should say. It is costly, very time consuming, and emotionally draining. And I think that last point is probably what most people don't consider much at all, which is it takes a lot out of you. As lawyers, when we deal with litigation, it's objective, it's not the biggest issue. I mean, it's not us, but when you're going through it yourself, it's a lot more anxiety ridden, frustrating, and emotionally up a roller coaster. So try to avoid it, but that's what it comes down to. But there's a lot of predictability with litigation. Arbitration usually tends to be between 1 and 3 arbitrators on a panel. If you go secular, you have JAMS, you have American Arbitration Association, or you can even go to Besdin, is a form of arbitration if both parties agree to be bound by that. They usually have rules that they keep to, but it's not public. It tends to be substantially faster, and as a result, tends to be quite cheaper as well. But with litigation arbitration, any decision that whether the judge or court or arbitrators come to, it is binding. With court, if you don't like it, you can appeal if you think they did something wrong. With arbitration, the decisions they come to are very difficult to appeal, and it would have to be a really big issue that they did in order to appeal. Is a lot more of a limited scope to appeal. Last one that I see most people using is mediation. Important to understand, mediation is non-binding. Inherently is just good faith efforts by both parties to come to some sort of resolution. It's best to kind of deal with this going into the contract. So you may want to say we can mediate for 30 days. If that breaks down, we'll go to arbitration or court. But there's no specific guidelines to mediation. Usually you'll designate one person, and it's really just kind of discussions in good faith to figure out a good resolution. One last point to kind of bring up is a lot of people believe in court, when you win get judgment or whatever it is, you win. It's only the beginning. You then have to enforce the judgment, which is a whole nother thing. So at the end of the day it's not about the fight. It's always about coming to some sort of resolution. As you saw on one of the slides, 95% of cases don't even get to trial. They most generally settle out because that's the easiest way to go about it. With that being said, one last point I would like to make is lawyers are not, it gets lost on people. It's not a boilerplate. When you say, oh, can I get a contract for this? A good lawyer will sit you down, understand what your needs are, understand what you're trying to protect, and draft an agreement to that. Sure, they're using a template for some parts of it, yeah. But it's both parties working together, both the client and the lawyer, to understand what is the best practice, best protections, etc. But it's not simply like, oh, let the lawyer deal with it. The more involved you are, the better protected you'll be, because it ensures the lawyer understands what to protect. With that being said.
All right, so we're going to jump into Q&As. We have a few questions pending on the chat, and then I'll also open it up to more questions. So someone, Menachem Tenenbaum, if you want to explain protection from NDAs overseas with sensitive data, you want to maybe unmute yourself, Menachem, and explain your question?
Sure. It's funny. I hear this question from everyone all the time. Nowadays in our generation, we're very into outsourcing and bringing people into companies from out of the country. So that just brings up if given data, is there any way to really protect yourself with via NDA from overseas employees?
So the question I'm going to have is the NDA to protect the company in the States or the company overseas?
They're usually always out of.
No, he's saying he wants to hire basically a VA or some people from India and China. And
practically speaking, it's very difficult. You're working with someone in some far country. If you're going to sue them in America, they're never coming here anyway. So what's the point of having a judgment or any order here? It's not going to really give you much. An NDA in that situation, you may want to kind of work it over there. The question turns into is the dollar figure that you're talking about. If you're trying to protect $1 million idea, then sure, you want to ensure that it works. But if you're talking about, let's say, a VA, if they take the data or something like that, one, how are they going to even use it? But two, I would say is protect your information and your data by saying that you are the only one that can disclose it. So let's say they can only have the ability to screen share through you to see certain data. You basically don't give them the full access to take the data itself, but they could view it. So they should be able to copy paste it. That's an IT thing that I would suggest, that I generally would tell most clients to deal with. And having the NDA gives you some sort of comfort, but reality, like practically when they're not subject to this country or anything like that, they're not going to be here. Any sort of judgment's not going to have much in effect. It's more of a practical approach that you would have to take. Than
now, one other follow-up over there, and thank you for that. But if a lot of there are a lot of companies out there that you can hire these VAs from them. There's nothing you could do. You can work out with them. Is there any leverage there, or it's the same?
So potentially, if they're bigger, you may want to have the NDA subject to that country. Again, it's going to come about costs of if you have to go down suit. You're also now touching upon issues with privacy laws, data protection, GDR, which it depends if it's across Europe. Certain countries that have that. You're touching upon a variety of issues that you want to protect either way. But having a two-stage verification. So for example, they want to access anything, make sure it goes through you, things like that. But you bring up an interesting point. Employment laws internationally can be quite complex. So having, let's say, a organization that you're hiring through really does actually provide some level of protection for you here. Because if you're, let's say, quote unquote, underpaying them, or you're not adhering to some local laws, you're subject to potential liability. Versus if you're hiring a third party to do all of that, those obligations generally tend to fall on that third party as opposed to you. So I've advised clients, even if you can hire directly, it's worthwhile going through a third party just for that additional protection, generally.
Thank you.
Okay, next question we have here from Shaiki. What is the average cost of a contract?
Really depends on what type of contract you're referring to. If it's an NDA and super standard, it's not much. If you're talking about a sales representative agreement, let's say that's commission based, and there's a variety of factors, it's gonna be more expensive. If you're talking about a partnership agreement, it really depends on the circumstance. Giving an answer would be foolish of me to say the very least. But some lawyers work on an hourly, some work on flat fees. At the very least, it doesn't hurt to just have the conversation. Most lawyers would have like a consult for and not charge for it. Talk to them. At least you're going in eyes wide open. It doesn't hurt to know what the cost would be, but it varies depending on the circumstance.
Okay, next question from Chaim Yitzchak Klein. What would be the best practice or way to dissolve a business partnership that did not have any legal contract for the initial partnership?
So, if you don't, let's say I'll go with an LLC here. If you have an LLC and you don't actually have any binding agreement, it's gonna default to statute. So New York dictates how these things should happen. If you both are on board with dissolving the company, my suggestion would be is quickly have an agreement that you can dissolve it, or have like minutes or a resolution of the company that both parties sign, that they give authority to one party to go to the state, put in all the papers and everything else. That way you have authority from both of you. I'm assuming this is just two parties, partners. Now one has authority to go through the entirety of the process to dissolve, but the dissolution should not be complex. The first step should be is get something signed so that if things start shifting and changing,
I think the question is that it doesn't seem that they want to dissolve the company. It's that they want to, company wants to keep on going, but one of them wants to step away from the company.
Oh, I'm sorry, I misunderstood that. You would then have to do a sale of the equity. So if it's again with an LLC, if there is no agreement, that's fine. You would do a purchase and sale of the equity. It would be important in that agreement to ensure that like you're not maintaining any liability moving forward of whatever business that goes on. So the leading partner wants to make sure that no liability from the day he walks away or she walks away is theirs. And usually that's one of the biggest contentious parts, and the purchase price and how that's being done. What happens if if it's not a one lump sum? You have to then, it gets a little bit more complicated because what happens if they don't pay you out fully? Do you get some of the equity back or not? And it depends which side you're on about how you would want to address that. So it really depends if you're a buyer or seller, and how the payment is working, if there is sufficient payment.
Okay. I'm sorry, was that answered fully? Should I move on? No, I'm not talking to
No, I know. I'm just saying, it's like I only touched on it. There's a lot of other factors that would need more detail for me to give a clear answer to that, but I didn't want to kind of ramble on too long.
Okay, from Mayor over here, how well would terms and conditions work to prevent lawsuits? What about insurance? Does this cover everything?
Terms and conditions in what context, like on a website?
Mayor,
or
you want to
contract?
unmute yourself and explain your question? Mayor, are you still there? Go ahead, speak loud, explain your question.
So basically, regarding a lawsuit, if I try to include everything in terms and conditions, and it says clearly something, and that person is coming against the company, can that be something that can prevent the person from going about a lawsuit or no?
So depending on if it's B2B, you have a lot more room to maneuver, meaning business to business relationship, or if it's B2C, there's inherently some consumer protection laws there that you can't waive. But if it's, I'm going to go with the assumption that's business to business, you can put things in there that they waive certain rights. You can limit your potential liability. You can also limit what you warrant and what the goods are for. So for example, there's implied warrants. Let's say you give someone a pen, it's implied the pen should have ink and it should work. You could technically write that it's as is, and you mean you're not making any representation to its functionality. So again, it depends on what goods, services you're dealing with, what industry, who's your buyer. But yes, you could have contracts together that can limit some of that liability and avoid some issues that could end up in the court.
And if it does happen, a lawsuit, does the insurance take care of it usually?
Depends what type of lawsuit, depends what type of insurance you have. But I would speak to the insurance broker. It really depends on the insurance policy that you have.
Okay, thank you.
All right, we have a last question here posted from Shaiki. A contract with a client, if that's international, how does that work? You have to get a lawyer from the other country? Like, well, how do you?
It depends again on so many factors. Wow. They could be an international company, but if they have offices and locations here, then you wouldn't be concerned about having venue and choice of law in the States. You obviously want to have that if a dispute occurs, it should be where you are because it's most convenient and most comfortable not having to travel internationally. However, if you mean they have no association with this country, you would be more inclined to, let's say, have the laws and everything else subject there and using an attorney locally there. So if anything goes wrong, you have something to go for. Now, the reason why I bring that up first is because if you have judgment or enforcement, you need to be in a place where that enforcement's effective. If they're not based in the States and there's nothing here for them, there's no good use of you having an American judgment, unless, again, there are some laws, but the Geneva Convention that you can kind of move the judgment over to that country, it gets complicated. It's a long process and not so easy. Maybe smarter and better just to have a contract, let's say, based in the UK and sue them directly there if that's where everything is. So again, it depends on the company you're contracting with.
All right, that's the end of all.
A big protection, I'll just add as a big protection may just be is having them pay part of it up front, making sure they hold some retainage. So you're always ahead of it. So if there's something arises, you're not going to be out of pocket. There are ways to protect against it, but that tends to be a little bit more on the creative and non-standard side of things.
Okay, so this is the end of all typed questions. Before we wind down over here, is there anyone else left that has any questions? You could raise your hand right now before we sign off to ask. Anyone want to ask anything else of Levi? All right, so it looks like we have come to the end of today's workshop. Thank you very much, Levi. This was very interactive, and this is the longest webinar of the year to date. Baruch Hashem, we covered a lot of information here. We hope you all enjoyed it. Of course, this has been recorded. We will post it to our YouTube channel for you to watch. If anyone wants to be in touch directly with Levi, how would they reach out to you?
Email is probably the easiest way. Levi at Ainsworth@Gorkin.com. Sure has all my information, or I guess I can give it to him to post it if anyone needs it.
Okay. Thank you. This was actually very enlightening. You covered a lot of things I had never heard before, which was great. And Shukayach, everyone that's on this, I wish you continued success on your business endeavors. As always, CHY is here to be your resource. If you have questions, looking for some sort of guidance, we have a very nice network of business volunteer mentors. It's always a free service for the community. We wish you all tremendous haslacha. There will be more webinars coming up every month. We do one. So look out in your inbox for our next webinar. Have a wonderful day, a wonderful week. Take care. Thank you, Levi.
Take care. Have a wonderful day. Thank you.